Good morning, everyone. My name is Cassie Hopkins, and I help coordinate the webinars for Hausmann Johnson Insurance. Thanks so much for joining us today. I want to welcome you to today's webinar, Documentation and Discipline, presented by Karen Bender, who is in our Human Resources Consultant team here at Hausmann Johnson Insurance. This webinar is interactive, and you will be able to ask any questions in that question box chat. You can type a question in during the webinar, or you can wait for our Q&A, and Karen will answer all questions during the Q&A session. After the webinar is over, we're hoping you can fill out a short survey for us just based on your feedback from the webinar, the speaker, and the webinar topics you're interested in learning more about. Just a reminder that this webinar is recorded and will be available on our webinar archive section of our website. Everyone who has signed up for the webinar will receive an email with a link to the recording of the webinar as well as the presentation slides. I would now like to introduce you to our speaker today, Karen Bender. Karen joined Hausmann Johnson Insurance in 2017 with over 30 years of human resources experience. Her experience includes regulatory compliance such as FMLA, EEO, FLSA, HR and safety, benefits, wage and salary administration, employee relations, training, and payroll. The majority of her industry experience is in insurance and manufacturing, and she is knowledgeable in both union and non-union environments. Karen also provides training services to the UW-Madison Small Business Development Center in HR areas, and she also instructs a class for the UW-Madison Division of Continuing Studies. Further, she developed teaching courses targeted at providing small businesses with HR guidance and employment law review to help them maintain compliance and improve their processes. Karen enjoys working outside, spending time with family, reading, traveling. She has traveled to over 23 foreign countries so far, including hiking throughout Europe, a 1,000-mile snowmobile trip in Canada, and exploring the off-beaten path of China. We are so glad to have you, Karen. Welcome.
Thank you, Cassie. Good morning, everybody. I hope that you are all safe and healthy wherever you are joining us from. As Cassie said, we will be going through a documentation and discipline session this morning. This is just a reduced presentation from a 4-hour class that I do have that covers documentation, discipline, and termination. So I realize there will probably be a lot of questions because we can't hit all of the details. And we will deal with those at the end if there's time. And if Cassie receives more questions than we are able to answer, we will follow up to all the participants with an email answering the additional questions that are received if there's not enough time to answer them all. So why do, Cassie, I don't seem to have control. Okay, there we go. Thank you. Okay, this is a very complex topic. There's, everybody in different situations, different industries, different companies are going to handle these things differently. They're going to have different tolerance levels for whatever the issue is. So for absenteeism, for poor behavior, poor production, late deadlines, people are going to have different reactions to that. And things often change. One of the, 10 years ago or 12 years ago, when the, when we were going through that recession, people would not tolerate a lot of bad behavior. They would be able to fire somebody and there would be somebody else waiting to get in line. Now, the last couple of years when I've been teaching this issue has been different because many of the students the participants were feeling like, I can't fire them because there isn't anybody that's going to be better. That is, I just have to have a body in place, because we all were experiencing bad customer service, et cetera, because of the low unemployment. We don't know what's going to happen in the next couple of months, but that's just another factor that affects how you're going to decide to deal with these different situations. So, Okay, I'm not, Cassie, I don't seem to have, there we go. There's a delay, I think. So we're going to talk about the purpose of discipline and documentation, why we do that, why consistency is important. There are a lot of things that you do with documentation and discipline that are not regulated by the laws. A lot of things that we do in HR are regulated by the laws. A lot of these things aren't. We're talking about things that are best practices, in my opinion, is what we're going to talk about today. But consistency is important because if you are inconsistent, that is when you can be breaking the law. For example, if you treat young people one way and then treat an elderly person a different way, or any protected class differently, those inconsistencies can be illegal, even though all the discipline that you did was legal. So we're going to try and talk about that, and I will remind you at different points in here where the consistency is important. We're going to talk about typical steps to follow, and we're also going to talk about managing remote work in this environment. So the purpose is to provide you with a foundation of knowledge to give you confidence and skill to handle the situations when they arise. If you don't know what to do, you can really flounder and really struggle. We get a lot of calls from clients who just don't know when to do, what to do, when to do it, and how to do it. So hopefully this will give you a foundation of knowledge, if you don't already have one, that will give you the confidence and skill to start building a process. I want to start by telling you I'm not an attorney. I created this presentation from my knowledge, my experience, training, and everything that I have had throughout my career. And I unfortunately have had to do a whole lot of discipline, documentation, discharge, terminations. And so my presentation comes from that and is not intended as legal advice, because too many things depend on factors and the whole situation, not an isolated incident. So before you discipline, before you do this, ask yourself, does the employee know what they were doing? Or did they know they were breaking a rule or not meeting your expectations? A Gallup poll recently showed that employees were surveyed, and they said one of their #1 frustrations was the fact that they were disciplined for things they didn't know they were supposed to do. And I've been in that situation where a boss has said, "Where's your business continuity plan?" And I had no idea that I was supposed to have done one. And there were issues. So it's just you got to ask yourself, have I done what I'm supposed to do? Does the person know? Have they been trained? Do they know what they're supposed to do? Have I removed obstacles? Do they have the tools they need? Do they have the time? Do they have the materials? And then when we switch, when so many companies have switched to working remotely, did you talk to your employees about your expectations of working remotely? Are they working more hours or fewer hours? If they're getting interrupted less, are they getting more work done in less time? Maybe they don't need to work the 8 hours. Just figure out what things have changed. Do they have kids around? Do they have, or what's going on? Make sure that you have talked about what your expectations are now that they're working remotely. And bottom line, if they don't have the ability to do the work, you may not necessarily want to have a disciplinary discussion. It may take a different tone. It may be something to the fact of, maybe this isn't the right job for you, or maybe we can find something else. But discipline may not be the right action if you answered no to any of those questions. What is the purpose of discipline in termination? Bottom line, it's to change behavior. Same thing with our kids. Why do we discipline our kids? It's to change behavior. There's a variety of disciplines. You know, it could be from anywhere from coaching to timeout, but the purpose is to change the behavior to get it in line with your expectations. Excuse me. So why is this so hard? It's hard if you don't know how to do it. It's hard if you're scared of confrontation. Many people want, we want people to like us. I had a supervisor at one of my sites who was second shift supervisor, and if we made her discipline anybody, she fought it, and then if we told her she had to do it, then she would do it, and the next day she would bring treats for everybody because she felt so bad. All she wanted to do was have people like her. And you lose credibility if you step into the friendship role instead of the leadership role or supervisory role. It takes time, and so it takes time from our other work, and sometimes it's easier to ignore bad behavior. If you ignore bad behavior in your children, is it going to change? Probably not. It's going to get worse. And if you do that with your employees, the same thing is going to happen. If you have one bad apple consistently coming into work late and getting away with it, the good employees who have been there consistently are going to think, why do I have to be here on time if he doesn't have to be here on time? Also, we don't know what to say. So hopefully after this session, this will help you a little bit. And there is always the potential for unpleasant reaction. Anger, tears, or anything else, it's always there, and that makes it very hard. So, excuse me, I am not used to talking very much anymore. Excuse me. So, employment at will. Most of you have heard this term. It means it's a law, and it means that the employer can fire an employee at any time for any legal reason. It also means an employee can quit at any time for any reason. They don't have to give notice. The employer doesn't have to give notice under that law. However, and Wisconsin is an employment at will state. So I have people asking me in my classes and stuff, why do I have to do all this stuff if we're employment at will? The reason is just because you can doesn't mean you should. If you fire somebody for and just say, you know what, I don't like you, or if you just say you're fired, pack up your stuff and leave, you don't give them a reason, they're going to make one up. If they and their neighbors and friends who are working beside them, they're suddenly gone, the employees are going to make stuff up, and they may decide that they were fired for an illegal reason, whatever that is, and if you have not provided them with a valid reason for the termination, they're going to make one up, and you're going to end up possibly in court. So this is one place where it's very important to be consistent on how you treat your employees. Am I going to just treat them like they're disposable and I could just fire them and not give any explanation to them? Or am I going to walk through the steps that a conscientious, reasonable employer would do so that I can explain to them what they're doing wrong before I terminate them? What is the purpose of documentation? So documentation is so vital. It captures the facts so that you can refer back to them later on if you need them. So, and they become a legal record to help defend the company. A lot of times when employers go to court, whether or not they're going to like in front of an administrative law judge, an ALJ, work comp, unemployment, anything like that, many employers feel like they don't have a chance and that the judge always sides with the employee. But think about this. There's many times when the employer doesn't have the documentation. So if the judge says, or so if the judge asks the employer, did you tell this employee, did you talk to them about their behavior? And the employer says yes. And they probably did. Maybe they talked about it a lot. Maybe the employer did a lot of things right. Then the judge says, did they talk to the employee? Did the company talk to you about your behavior? Company might sit there, the employer might, may say, no, they didn't talk to me. The judge will look to the employer and say, where are your notes? Where is your documentation? And if they don't have any, they didn't do their job, and the employee will win. It's not that the employer did anything wrong with what they did and what they talked about to the employee and the process they followed, but if they didn't document it so that they can prove it, the employee is going to win. So because it is your job to do that. So make sure that you document things and that you're documenting consistently that the same things, and maintain those so that even if you leave the organization, the records are still available to whoever it remains. So one of the things that I think is really important, it's written proof of the steps that you attempted to work with the employee. Nobody likes to be blindsided. So it shows, like, if the employee says, I hear, what are you talking about? What do you mean I'm fired? You didn't talk to me. You have all the steps. Look, we talked to you on this date. We talked to you on this date. We talked to you on this date. I have had to do that where employees at the time of termination or suspension say, you never talked to me about this. And when you pull out the records and say, these are the dates that we talked to you, they realize that they have been talked to about it. They were just possibly blowing you off or not taking it seriously. You want to be able to feel that you have treated your employees fairly, and your employees should always feel that they've been treated fairly, even if they don't like the way they've been treated. If it's fair, if others have been treated that way, it's a lot easier for them to accept. So what needs to be documented? What legally has to be documented? The law requires documentation on many things. Now, you, depending on your role at the company, may not be responsible for documenting these issues, but the FMLA, the ADA, Americans with Disabilities Act, performance feedback, performance reviews, harassment claims, layoffs, etc., they all have to be documented. The decisions that are made on those, if training and development is offered, who's it offered to, that kind of stuff all has to be documented. Beyond that, if you're not responsible for any of those things, then when should you document? Any time that something occurs, good or bad, that you're going to need to recall in the future, should be documented. And we're going to talk about how to do that too. And any activity that can show that you treated employees consistently. So be careful, though, to not discipline for legal acts. People still call us at Hausmann Johnson and ask questions about disciplining people who are out on FMLA. Disciplining people because they called OSHA, disciplining people because of disabilities or anything like that. The employees have legal rights to legal leaves. Don't be very, very hesitant to ever discipline anybody on FMLA. Don't do it without talking to an attorney. Or other leaves. If you have a leave that's provided in your employee handbook or your contracts, whatever you have, make sure that you don't discipline people for using those leaves, unless of course there's abuse involved, but then get an attorney involved. Don't discipline them for reporting an injury or illness. Now, if they're reporting injury or illness, but they report it late, and your rules say they have to report it immediately, you can discipline for the late report. but that's not the same as disciplining for the illness or the injury. Do not discipline them for calling OSHA on a safety issue. They have the legal right to do that. Also, they have the right to notify you of a pregnancy and of a disability, and they should not be disciplined for doing that. So safety, when we talked about, I mentioned OSHA earlier, and many of you probably have safety issues. If you're in manufacturing or construction or a number of businesses, safety is a big issue. You can and should discipline for safety violations, because that can be defense to you later on in a work comp claim or an incident. So let's say that you have an employee stick their hand in a machine. If they've done it several times and not gotten hurt, and you knew they were doing it, and then they do get hurt, if you have a willful violation, that could be a willful violation if you knew of the danger and didn't fix it. You could be charged more. In the event of an issue where that person is sticking their hand in the machine, you have trained them not to do that. You have provided a guard, and you have done all the right things and even disciplined them for still doing it after being instructed not to do it. You can continue to discipline and possibly terminate for violation of these safety rules. But you have to proceed with caution. You have to be consistent. You have to have provided the training. They need to know, and you need to be able to prove that they've received the training and they know how to do it right. That you have disciplined them in the past for this action and told them, if you do this again, there's going to be future consequences. You have to use progressively more severe steps, and we're going to talk about those, and document. So what documentation is your responsibility? Handwritten notes or electronic notes from any coaching, counseling sessions that you've had with the employees. Be careful with your notes. Notes can be discoverable, emails, anything like that. It can be discoverable if an issue goes to court. Be professional. Do not make negative comments about the employee and their behavior. Do not, be careful what you say about them so that you are not showing a prejudice against them. Like, that SOB is late again, don't do that. Don't make comments like, he must be drinking, he's always late, he looks like he's hungover. Don't make comments like that. Stick to the facts. We'll talk about that a little bit more. You should document any investigation that you're doing, and many of those issues should go to HR. And we're going to talk about investigation notes later on too. Your notes that you take should talk about who, what, when, where, but not why. If an employee is consistently late for work, and I mentioned that maybe you're assuming that they look hungover and they're drunk or whatever, if you don't know that's the case, then don't say why. You can talk about who was late and what time they got there, what days this occurred, and where the issue occurred, at your facility. Some issues will require a specific location in the facility, but you don't know why unless the employee gives you an explanation. So that should not be in your notes unless they tell you. So typically these issues that you'll be documenting are violations of the company policy, procedures, or code of conduct. Attendance issues are a very common thing, and many companies don't know when. If they don't have an established attendance policy, don't know when they should be disciplining for that. If your company does not have a written attendance policy, and you start disciplining for attendance, make sure that you are selecting the worst offender to start with. Don't have 5 offenders that you need to deal with and you start with somebody that's number 3 or 4 because they know that somebody else has got worse attendance and is not being dealt with. Make sure that you know who's got the worst attendance and start with them. Consider putting up a notice saying, you know, because of bad attendance, we are going to, in 30 days or, you know, depending on how attendance goes in the next 30 days, we're going to begin to discipline. Consider giving them a warning so that all of them a warning, so that they can straighten out before you end up in a disciplinary situation. If you don't have a written policy, then how are they supposed to know what's acceptable? So be careful, you know, and be aware of the fact that from their side, it looks like anything's acceptable because there's not a policy. And and if you're going to start, when you start, make sure you start with the worst offender. So, training needs should be documented, and document too when somebody does a particularly good job. We don't tell them that enough. And it's always, it'll get you a ton of mileage if you document for somebody that does a legitimately good job at something and really stands out, that you document that and give them a copy and put it in their file. Just that little appreciation goes a long way. So if comments made by employees, so let's say that somebody says, well, I want vacation the week of deer hunting season. And you say, well, you know, if they tell you that now and you say, well, you know, if that's already full, you can't take it, then they'll say, okay, well, then I'll just take FMLA. And they storm off. Well, you'll want to document that, because how are they going to plan FMLA that far out unless they've got surgery scheduled? Those kinds of comments, you know, have to be written down. So then you talk about who said what, when, and when, you know, the day they said it, and where you were standing at the time that it was said. Disciplinary actions should be documented. Any disciplinary steps you take, coaching, first written, second written, etc., should be documented. And if you have to demote somebody or if you promote somebody, document your reasons and the support for those decisions in case those are challenged later on. So, employee copies, there's a lot of questions about this. A copy of any documentation which may lead to disciplinary action must be provided to the employee. That's often a disciplinary action form or a performance appraisal, and they should have to be provided a copy. If they ask for one a year or two down the road, you still have to provide it. You should provide it immediately when it occurs so that they have it. But if they ask for it later on, they do have a right to it. So if it's going to be done orally, then follow up with a written statement, and we're going to talk about that in more detail. The employees do not have a right to your investigation notes, and these should be secured. They should not be in the employee's personnel file. So let's say that Jim follows a harassment claim or files a harassment claim against his supervisor, Jane. You do an investigation and you talk to like 5 different people to get all the witness statements and everything else. When you do that, you create a separate harassment file and do not put it in Jane's employee file, because then she would have access to whoever made statements against her. So those should be in a separate file that she does not have access to. In the end, let's say that you do the investigation and you find out that she needs a final written warning for bad behavior, saying if you harass these employees again, then you will be terminated. That documentation, that final documentation that is the actual piece of discipline, can go in her file, but not the rest of it. She does not have access to that because generally, until they end up in court, she does not have the right to know who testified against her. When you use document, use language that is fair and honest, complete, and here it is again, consistent. Don't use terms like they have a bad attitude. Okay, well, you can't see a bad attitude. You see behavior that leads you to believe they have a bad attitude. For example, consistently late, rolling their eyes in a meeting, not participating, being short with somebody. You know, all of those things make you think the person has a bad attitude. Those are the items, those are the specific behavior that you describe. Don't say in your notes, employee has a bad attitude. If you say employee, you know, is consistently late, they roll their eyes at meetings, etc. List the things that you are seeing that lead you to these opinions, but don't list your opinion. Those comments, and this is not a complete list, make you are not sufficient to be solid documentation. So you say somebody's irresponsible. What's that mean? What have they done that make you think that they're irresponsible? Give specific behavior examples. When should you document? As soon as possible after it occurs. Don't go back and try and recreate a case, you know, that because, you know, we can tell and yeah, generally HR can tell, and so can the courts, and that's not good. Do it as soon as feasible after the occurrence. So when you're documenting discipline, so for example, in a written form or in an email or talking your notes about talking to somebody, there should be at least 3 parts. In addition to talking about who, what, when, where, you will talk about the infraction. What did they do wrong? You'll talk about your expectation. What should they have done? And you will talk about consequences of future incidences. I put this on every disciplinary action form or counseling form that I did. Future incidences will result in further disciplinary action up to and including discharge. First of all, if you put that on all of them, you're consistent. Second of all, you've warned them that continued bad behavior is going to warrant further disciplinary action. You've advised them of that. And then you're advising them also that this is serious, that you take it serious, and that you do mean it when you want them to change their behavior. But you have to do infraction and expectation right in order to get the true impact of their behavior across to them. So we're going to talk a little bit. Whoops, I'm missing a slide. I think that one was supposed to be, yep. That one was supposed to be about recording I'm going to start talking about remote actions now. And we were talking about documenting. On a remote, with all your people, or so many people working remotely now, the question is, or the issue is, and we're often asked, can we record the conversation? The conversations in the state of Wisconsin, the conversations can be recorded if one person, you, knows the conversation is being recorded. It is legal to record. Now, be careful with the fact that they may, even if you're not recording a conversation that you're having, they may be recording it because people are nervous and they're, you know, and they are trying to protect themselves. They may be recording your conversation, so always be professional. And depending on the technology you are using when you're talking to somebody, that may be recorded automatically. for example, this webinar is being recorded. So that technology, you have to understand the technology that you're using, that you can record, but they can also record you without you knowing about it. And if you are talking to people in other states, find out or understand what those states say about recording. If they say no recording, or that everybody has to be advised that you are recording, follow those state rules. I apologize for the missing slide. So also, remote versus face-to-face, historically, discipline and coaching sessions in workplaces have been face-to-face. Many times they're done on a disciplinary action form that the company has, because that form's easy to follow and it gets all the, requires you to list hit all the high points, when, where, who, what, etc. Now it could be, when with so many people working remote, it might be a phone conversation or a some kind of a online call, like a Zoom conversation or Teams conversation. If you are going to be giving and counseling an employee over the phone or online and not seeing them and able to hand them a disciplinary action form, write out your notes for the discussion so that you hit the key points and you can get everything covered. That's also going to help you with writing up your notes after this conversation, because you're going to ask you to do that too. If your company does have an employee action form or a disciplinary action form, you can use that and you can send it to them and then go through it. You can email it to them and then go through it online if that's the way that you want to handle it. So after your phone call or Zoom or Skype, whatever you're doing, then follow up that conversation. If you haven't sent them the disciplinary action form, follow that up with a memo to the employee outlining the discussion. On such and such a date at such and such a time, we talked about the fact that you did this. We talked about our expectations and the consequences of not following that. And I had provided verbiage for you to use on that. Then when you send them that email, then you could ask them, would you agree this summarizes our conversation? Do you have anything that you want to add? Are there any concerns or anything like that? Then if they respond to that, there's your acknowledgement that they received it. Or ask them, to please let you know that they have received it, or ask them about any concerns that they have to verify that they received it. If you're not sure that they will respond to that, then attach a read receipt and to the email so that they're opening it. And you can see that. Any response from them shows receipt. You don't necessarily need to do that at these steps. If they don't respond and you forget to show a receipt, then maybe you want to mail them a copy also. When I've had conversations with employees and they were being really obstinate and really not listening to me, but just forming all their excuses and denials in their head, I would often follow up. Even though I did it face-to-face with them, if I felt I wasn't getting through, I would still mail them a letter at home just summarizing our conversation, because I didn't feel they were listening to me. And that's just another step that you've taken to ensure that you've made an effort for the employee to succeed. So here, let's talk about the documentation we talked about earlier. Here's an example. I have seen documentation. I do a lot of audits of different companies and stuff, and I've seen documentation bad, that's so bad that says, one time I saw one that says, you missed too much work. Well, that's not very effective in changing anybody's behavior. But here's another another bad example is you ran bad product, didn't fix it right away, and you didn't tell your supervisor. Okay, if you write an employee up with that kind of a statement, they don't know exactly what bad product you're talking about, because maybe there's been more than one and you only caught them once. They didn't fix it when you don't even, and they don't even know what you're talking about, and they didn't tell their supervisor. Be specific. Here is an example of doing this better. Same incident, same employee, same behavior. You're receiving this because you allowed poor quality product, in this case unsealed product packages, to run for 5 minutes, resulted in a lost product of approximately $250. So that's what they did. By putting in the details, it was an unsealed package, was 5 minutes, and here's the value of the lost product. That is providing you with a foundation for the future, for future incidents. So let's say that the next person, a couple months down the road, somebody else does something and they let it run for a half hour and they didn't fix it, and the costs were in the thousands of dollars. You may take a stronger position and do more discipline for them because of the magnitude and the severity of the violation. So if this was a first written, somebody who caused a whole lot more damage and loss may be given a second written as opposed to a first written because of the magnitude of the issue. And you have this as support for your decision. So then we go on to talk about the expectation is monitor your machine, minimize waste, notify your supervisor immediately. So you've told the employee what they did wrong. You've told them what to do in the future. And you also say, you do it again, future action up to and including discharge. Safety ones, and I've got a couple caveats in here that will help you too. You're not wearing your earplugs like you're supposed to. Well, that is of minimal value. So if you said, a lot of times when people are not wearing their earplugs, or it's apparently initially a fairly minor issue, we'll warn employees. We'll tell them, put your earplugs in, put your safety glasses on, do this, do that. And we'll tell them, and we're not writing them up every time. But possibly the third time you say, I don't know what, I'm not getting across to you. I need to write you up and get your attention. And this happens over and over again. So in this case, I'm saying over the past 2 weeks, I've told you on at least 3 occasions to wear your earplugs. That's number one. I'm going to talk about that a little bit more. Company determined you're working in high noise, and noise reducing is mandatory. Noise reducing earplugs are mandatory. That's number 2. Then I go into into the other details. You're getting your first written warning out of compliance again today. Here's our expectation. Here's future infractions. So the first statement was, over the past few weeks, I've told you on at least 3 occasions to wear your earplugs. A lot of times, we have not documented the fact that I walked past that guy 3 times and told him to wear his earplugs, but I didn't make documentation on that. But I remember I did it. So it documents the fact that you told them, even if you didn't write them up for it. And it's very unlikely that you have a note that says, I told them. You might not remember exactly when you talked to them, but you did it 3 times. I have done this on many occasions, and I have never had anybody say, no, you didn't talk to me. They all admitted it. Now, it's very possible that your employees are going to, that they're going to say, you didn't tell me, and then you have to reconstruct the best you can in your mind how many times you did this. And then this statement about, as you know, the company recently determined you're working in a high noise area. So this further documents the fact that they were advised earlier, they're being advised again, and again, it shows fairness and progression. If you have done all of these things, it's very hard for them to argue that they have been treated unfairly. And it's very hard for a judge in any situation that has this documentation that shows that you did all of this. It's very hard for them to rule in favor of the employee if you continue to do things right. If they sign this, or even if they don't sign it, they have they have a harder argument to say that they weren't told or trained. So again, on the documentation, include the date of the infraction, the date of the write-up, because it's probably not the same, your name, title, and signature. And again, any of the facts, the costs, the time period, etc., that reflect the severity, because then you can build on that and show fairness and progression if you treat similar incidences the same. Timing is important. Do the discipline as soon as feasible after the occurrence, because if you think this is a big enough deal, that their behavior was a big enough deal that they should be written up. I've seen people wait up to a month to do it, and I'm thinking, well, they displayed bad behavior a month ago and you haven't done anything about it. You've allowed them one more month to display bad behavior and you haven't even done the first written step. Same thing with attendance. If you hit the point of attendance or any issue, if you hit the point where this needs to be dealt with, deal with it promptly. Because if you think Monday was the last straw, if you don't deal with it until Friday, you've given them 3 or 4 more days to display bad behavior. Consider an EAP. If you have an employee assistance program, consider referring to that in your write-up. So talk about the 3 things that we talked about: the infraction, the expectation, the consequences. But if it's a situation where they may benefit from an EAP, and that could be financial, drug-related, alcohol-related, family issues. It could be any number of things that is causing this bad behavior, especially if you've got an employee that has been pretty good and now is displaying bad behavior. Refer them to the employee assistance program and make a note in your write-up that says, I encourage you to consider contacting the EAP if you have personal issues, if you have personal issues, and do this before it gets you into trouble with your performance. You are only dealing with performance issues. The personal issues may be translating into performance issues at work, but you are not dealing with the personal issues. You are not a licensed counselor. You may have liability for them if you think that I'm just counseling them and I'm helping them out. You may not be. You're not a licensed counselor. You might be going down the wrong road and you may be making things worse. You could tell them, I'm sorry that you have these issues, but you'll have to talk to a licensed counselor. I am not qualified. And mostly you don't want to know, because if later on you have to do any discipline or layoffs or any other issues like that, and you have too many, and you know what's going on in their life, it's going to make that decision more difficult. So typically there are 4 progressive levels of discipline. Typically the first one is a verbal or a first written, typically a second written, then finally a final written, and some companies choose suspension. That's up to you and how you manage that, and typically termination. If you have a progressive disciplinary policy, take time to review it. Does it meet your needs, and are you following it? I've seen some policies that will say, when we observe bad behavior, we will coach. If the coaching doesn't work, then we will start this progressive step. It doesn't allow the company to skip any steps. So in a situation where you have an employee who physically grabs another employee and hits them, let's say, or even if they don't hit them, even if they just grab them, you refer to your progressive discipline, and it says that you're going to coach them. So then they have to be coached. They're allowed to grab somebody 5 times before they're terminated. That's the way that's written. Make sure that your policy says the company will decide the proper discipline based on the facts of the situation, and we may skip steps. If the situation is serious, And like I said, the employee grabs somebody, and let's say they were in anger. You may want to go right to a suspension and say, I want this employee out of the building. You can send them out to protect your employees, to protect your property, and everything else while they are out. You do not need to give them paperwork. You just need to get them out at that step. You just need to get them out. But while they are out, keep the whole investigation process moving so they're not out for 3 weeks or a month before you do, before you even investigate. Do it as quickly as feasible. If they are out and they're not working and they're not getting paid, the non-exempts, you do not have to pay your hourly employees. But if a salaried person does something significantly wrong or bad enough to be suspended, check the Fair Labor Standards Act, because you may need to you may need to pay them depending on the situation, because exempt employees cannot be docked except in very rare circumstances. So even if you think that you're having a financial impact on that salaried employee for their bad behavior, you may not be. So check that out. If after your investigation you were wrong and somebody didn't deserve to be disciplined or suspended, consider paying them, because it's not fair if you sent them out. I mean, you had the right to do it. You had the right to suspend them, and you probably did the right thing, but the investigation finds there's no wrongdoing. It's the right thing to pay them for the time missed. So, okay, we talked about this. Don't write it so tightly that you are locked into the steps. If your policy in your handbook, if any policy in your handbook needs to be revised, revise it and get it out to the employees, because if you have a policy in there, you are supposed to follow the policy. So either revise your handbook or follow it. You shouldn't have something in there that you are not following. Think twice before disciplining in issues where others have done the same thing and not been disciplined. For example, the attendance issue I used earlier. If you're going to discipline somebody, pick your worst offender. So unless the rules have changed, maybe you post something and say, okay, these are our new rules. Sometimes the differences in employee history justifies different treatment. For example, a 15-year employee suddenly misses several days of work for personal issues. They may be treated differently than the new hire who misses several days of work during the first month. You may decide that that's not right. They are going to be terminated because they're in their initial period and they're not performing. Versus this person with 15 years, we know they have a demonstrated good record. We can show a little leniency. Make sure that you don't, be aware that retaliation may be occurring. Sometimes employees will set each other up. Sometimes other leaders and supervisors will set up their employees or select them for less favorable treatment, etc. So we're talking about, and at the bottom we talk about the rules are unclear and conflicting laws. I am going to create a webinar that we will be advertising in the near future that talks about how to handle discipline documentation and stuff when you have conflicting laws. So we'll talk about that at another time. Must the employee sign a written disciplinary action? No. They don't have to sign it, and that doesn't change a thing. You can ask them, if you're using a written documentation, a written disciplinary action form, and of course performance evaluations are written, you can ask them to sign it. If they say, no, I'm not going to sign it, you can ask them to write refuse to sign there. If they write refuse to sign, then you can do it and do it in front of them, sign it, refuse to sign, put your initials on there, put the date on there, and then still give them a copy. It's still disciplinary action or performance evaluation, and they still have the right to it. Make sure your forms say, I acknowledge receipt. You're asking them to sign that they acknowledge receipt of the document, not that they agree with what's written in the document. This document, if you've done all these things, still is a valid disciplinary action for them, and they should still get a copy of it. If they do not agree with what you wrote, you can tell them to write an appeal, and that appeal will go in the file with the document. And do we have any questions? I want to turn it back over to Cassie.
All right, everyone. If you look at the question box on GoToWebinar, you can type in a question. I'm going to just start with some of the ones we received during the presentation. So one of the questions is, how long should you keep the paperwork in an employee's file?
Any documentation regarding discipline, I kept indefinitely. In situations where you're making decisions about performance, and sometimes you're making decisions about raises, demotions, etc., like that, some of that stuff is covered under the it's the Lilly Ledbetter Act, and the name slips my mind, Fair Pay Act. So if anything, some attorneys say keep that indefinitely, even after the employee terminates, because any paperwork that involves a decision regarding pay, and discipline and performance affect pay in some cases, should be kept indefinitely in order to defend yourself against a fair pay or equal pay issue. So it should be kept indefinitely. Should be in a separate, maybe you have, if you have paper files, have it in a separate file that's just marked performance, because if that person signs for another job, then that whole performance file should go to the new supervisor that is considering them for the job.
Great answer. How much time between actions is reasonable?
Good question. Many union contracts will say that all of the activity between the first written and the termination, so let's say it's a safety issue, order of attendance, before safety issues, they should all occur within 1 year or 12-month rolling, doesn't have to be calendar year. So if somebody's written up in July and September, and then again in January and March for the same thing, and they've been progressive, typically 12 months. That is not the law, but that is defendable. And some companies have more. I wouldn't go a whole lot more than that on some of those issues. More serious issues can stand for longer. Serious harassment issues, I would think, you know, if it was a couple of years ago that you were warned not to do this again and you're doing it again, it may warrant termination, but I would contact an attorney before doing that.
All right, next question is, if you have to suspend someone and get them off your property because of bad behavior, do you have them do paperwork first, or do you have to give them paperwork?
No, if somebody is in a situation, and they're often emotional or volatile situations, is why you would suspend somebody to get them off the property, then no, you do not have to take the time to give them the paperwork and the written documentation. You can follow up with it via email or via written mail, or when you bring them back and have them sign it. But no, the main thing is protect your company, protect your employees, the other employees, and have this person leave your premises so that you can so that you can do an investigation and do it in a calm, controlled environment.
Very nice. All right, well, we have just hit 10 o'clock and I want to be respectful of the time of our attendees. So I want to thank you guys again for attending today's webinar. Please fill out that short survey. Your feedback is incredibly important to helping us create more webinars. As Karen mentioned, there will be a more complex webinar addressing some of the legal issues with documentation and discipline. And we will also have another upcoming webinar preparing your business for reopening from COVID-19 shelter from home. If you have not subscribed to our email, that's where we'll announce those webinars and those dates. So please subscribe to our newsletter so you can see that. And we want to thank you again and have a great rest of your morning.
Thank you, Cassie.
Thank you, Karen.
Yep. Bye.